Good morning. Are you Lric Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because, you know, on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it, and all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous. Okay? All right, go back with the bailiff. I'll reset the case.
Good morning.
Good morning, ma'am. You're Desiree Kirks?
Yes, ma'am.
And Ms. Kirks, in cause number 24, DCCR 0518, you're charged with the 3rd-degree felony offense of deadly conduct discharging a firearm from February 9th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Kimmler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year deferred probation, a $500 fine, and you would be required to follow any and all rules of probation. Do you understand what the offer is?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you're found guilty and what your possibilities are or options are if you go to trial. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, and Mr. Nichols, is there any reason to believe that that offer would change or any information you don't have?
I don't see anything at this point, Your Honor.
So, Ms. Kirks, I want to make sure you understand that after today, I will not accept this plea agreement. So if you change your mind later, you could enter a plea of guilty, but it would be to something different or just open to the court. Do you understand?
Yes, ma'am.
All right, and so we will get it set on the trial docket. Mr. Kimmler will begin preparation for trial.
Okay.
All right, you're free to go.
You got it.
And then on Ryan Hodge, Mr. Kimler. I mean, how long? I was about to say that's been 35 minutes. Good morning, you're Kingston Walker? And Mr. Walker, you were previously here and given some time to hire a lawyer. Did you get someone hired?
I spoke to multiple lawyers and I chose a lawyer, but I just need time to forward the payment.
Who'd you talk to?
Burbanks.
Okay, and you're planning on hiring Mr. Burbank?
Yes, ma'am.
All right, so, and you're working?
Yes, ma'am.
Okay, so what I'll do is reset your case about 30 days to give you some time to see if you can get him hired. If you do, just bring that reset notice that you get today to him in his office and they'll tell you what to do. If for some reason it's not going to work out with Mr. Burbank, then I'm ordering you to visit with at least 3 others. See if one of those works out. If fine, great. If not, bring me those names so I know you're trying, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you that reset notice. Good morning, you're David Holland. And this is 21-36992, and what is the announcement?
Judge, it's hard for me to understand him, so with your permission, he's got a lot of the money today. The rest of it, he says, will be...
It's coming from the bankruptcy court, because where I used to work, the owner died and they filed bankruptcy, and I talked to him, but I got a letter 2 months ago, said they're allowing me $1,750 for what they was owed, which they owed me $21,000.
Judge, if I may, sorry to interrupt, before we get too deep in the weeds, the state's made an alternative offer. The offer is 2 years state jail, or if he pays the full restitution of $2,334, we'll do some form of punishment by county jail. My initial offer was 30 days county jail in the alternative.
Did you bring that documentation?
I forgot it, but they told me I talked to them Thursday.
So here's the thing. Last time you were here, the whole point was to give you time to get this taken care of. It would be something I would think you would think was important to get to Mr. Boudreaux or get to me to show that you're getting this money. So forgetting it is something that a kid would do, not a grown man. I'm resetting your case 1 week. You need to bring some documentation, otherwise your case will get taken care of. Hang on, don't talk over me. Otherwise, your case will get taken care of next Monday by a plea, or it will go on the trial docket and there won't be any pleas after that. Okay. See you next week.
Thank you.
Thank you, Judge.
Thank you, sir.
Mr. Holland has a 5-3 warrant, but we can't find it.
Next Monday.
Would you ask him to
Yes.
follow up on this and see if he could find us?
Mr. Holland, but y'all can't figure it out.
And then we find it, but it's in the system. It's a 5.
Mr. Holland, apparently you have a traffic violation that has resulted in a warrant. For some reason, it's not coming through our system correctly, which is probably a benefit to you because you would be taken into custody today. You need to get that figured out and taken care of before next week. Okay. Thank you. Yep. Ashley. Good morning, you're Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson was previously in court, entered pleas of guilty in all 3 of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think. And I'll ask my client to clear it up. Now, you were working for a home health care agency, is that correct? And
Answer yes or no, please.
And your client, actually at the time, had asked you to dispose of some personal life insurance, is that right?
Yes, and I took them. I misspoke. I meant to say I took the chicks, and I knew that Adrian Hayward was gonna cash up, so I'm just as guilty as him.
Of the four.
So, and she said in here that she's the one who took them.
Yeah.
So I'm
Mr.
okay with
Smith
that.
brought it up, and
Okay.
I want
I had
to clear up culpability.
I appreciate that. Yeah, I
And,
agree.
they've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss them, but I didn't have paperwork on probation.
Okay.
Um,
What,
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an
The
emergency?
plan is
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and they,
We can go talk to Judge Shelton, maybe, or no, this is fine.
no, I mean, that's as long as but she's gonna have to give her probation officer documentation from CPS. So you can work that out with your probation officer. So mine's gonna be no unsupervised unless, and then if
yes,
probation
okay.
gets that information and she's doing her safety plan and everything, then we're gonna be okay with that here also. But they're gonna kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay, all right, so Ms.
Just
Johnson.
thought is what they told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, ma'am. Thank you, Mr. Frazier.
Thank you.
Good morning. Are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan, in cause number 25 DCCR 1094, is charged with the state jail felony offense of unauthorized use of a vehicle from June 3rd of 2025. That indictment alleges a prior offense of accident involving injury or death on October 16th of 2017. And then after that was final, convictions on October 17th of 2022 for evading arrest or detention with the use of a vehicle and also possession of a controlled substance, a second-degree felony, making this, if all of that's true, for punishment purposes, a second-degree felony offense. And then in cause number 25, DCCR 1317, charged with possession of a controlled substance. Let's see. Also a state jail felony, has those same prior offenses listed, convictions listed again for punishment purposes. That would make this a second degree felony offense if true. And what is the announcement?
Your Honor, he's instructed me that his family has hired a lawyer out of Houston to represent him, and I don't think he's had time to file the court, and so I asked that it be reset for him to make those arrangements. That's what he told me.
So whoever that is hasn't filed anything yet to show that he represents you. And so what I'll do, Mr. Trahan, is reset your case, a normal reset, which is about 30 days or so.
Yes, ma'am.
Mr. Parker will remain on until we get that information from that attorney. If for some reason that didn't work out or something didn't happen and he wasn't hired, then Mr. Parker will remain your attorney at that point, okay?
Thank you.
All right. Yes, sir. You can go back with the bailiff.
Lric,
Lric, trustee.
that's one that we reset. He's not, well, he may be here. We don't need to bring him out, though, George.
Okay.
But he's supposed to, his family's supposed to provide me a video or some evidence, and they've done that. We've had the investigator upstairs listen to it. Apparently, it was already sent to, I guess, BPD, or one of the agencies, so we need to get that for the prosecutor to hear. It's Mr. Coleman's case, Judge.
Okay.
So,
All right. Just a normal reset?
Yeah, and I'm gonna probably
we'll
need to
reset.
file a request for bond reduction, because based on what I've heard, it indicates that he may have actually used that on.
Okay,
And
yeah,
so I'll
if
do that.
we'll do a normal reset. If you file a motion for a bond reduction, we'll move it up.
Yes, sir.
All right, so trustee will get reset. Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I assume the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engaged in the type of conduct that caused this to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address the court as well. Is that right? You have to say who said it.
do apologize for the situation that went on. And I wish that anybody that was involved in the case will see that I'm overly serious and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full wage.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail. And then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
Judge, I'm sorry to interrupt you.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry. 25 DCCR 0979
That's the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the
Yeah.
case is going to get to close down.
Not again, you never gave it to me.
Well, I mean, when she first pled.
So do I
You didn't give
You
it.
to give me a
still get the credit for me being in here on this?
Yes. All the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you.
Is it 8 years, John?
8.
This defendant's
Yes.
in the hospital.
Who?
Robert.
Oh, the defendant. yes.
Defendant is in the hospital.
They're the same.
Okay. Whose is that? So we'll obviously reset, Desron Roberts.
He's in the hospital.
Okay. Mr. Chambers, in cause number 2137015, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 14th of 2022 for the offense of aggravated assault, family violence, second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation Count 1 alleges that you failed to report as directed to the probation department February 12th, February 28th, April 8th, and May 8th of 2024. And how do you plead to that charge? I mean, is that true or not true? I'm sorry. And then count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Not true.
Count 3 alleges that you provided a urine sample January 22nd and April 22nd of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? THC, marijuana. Is that true? Count 4 alleges that you failed to provide verification of performing your community service hours. And is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the Battering Intervention and Prevention Program. Is that true or not true?
I have a certificate that I completed the program.
Okay. Count 6 alleges that you failed to submit to alcohol or drug screening March 22nd of 2024. And is that true or not true?
No.
So it'd be not true. 2, 6. Count 7 alleges that you failed to provide verification of entering and successfully completing the Moral Recognition Therapy, the MRT program. Is that true or not true?
I don't know, because she told me to complete the bill class first, and I complete the bill class.
Okay, so I'll put not true for 7.
I'm gonna start the other class, because that's the class you do with the program.
I'm not sure.
Yeah, I never start one of the classes.
Okay. Count 8 alleges you're behind in your court-assessed fees as of May 21st, 2024 in the amount of $225. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes.
And you understand if I follow the agreement you made with the district attorney, you'll be waiving or giving up any right to appeal.
Yes.
And the agreement that you've reached is for a cap of 5 years. So I can give you 5 years if I revoke your probation. I can give you less. It'll all depend on the information I receive at a sentencing hearing. Do you understand?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chambers is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do an updated report. That'll give me more information about you, your case, and then we'll come back for sentencing. All right, you can go back with the bailiff. Good morning, sir. You're Norbert Freelo Jr. And Mr. Freelo is charged with murder, and Mr. Gilmore, Mr. Nichols, what's the announcement?
Judge, I don't think we're ready to set this for trial yet. I know it seems like every hearing I tell you there's stuff we need to investigate and find out, and there is still in this case. There's a potential witness who has given unsworn statements that is basically blown off appointments to give a sworn statement, and we need to run her down.
That's what we were going to do last time.
And they made appointments and she didn't show up.
Well, if we're talking about that one witness, she did meet with the investigators between.
Okay.
But there's also a new witness, another witness.
Okay.
And possibly some video footage that was deleted that I believe that Port Arthur Police Department is trying to get their hands on.
I need to check the status of the subpoena for that video. We need a little more time to it.
Okay. All right. We'll just do a normal reset. Y'all can work on that. We'll see where we are at the next court date. Mr. Freelo, make sure you stay in touch with, did you have something else?
I could, yes, Judge. I don't have a motion necessarily on file, but Mr. Freelo currently is on house arrest with a GPS device. His wife is recently been unable to return to work to the federal prison, so their income is limited. He's trying to find a job. It's been difficult, obviously, with the thing hanging off of your ankle and whatnot. So we were asking the court if the court would consider removing him from house arrest and GPS requirement.
No to both of those things, but potentially to, the GPS is going to remain on. I would consider, Mr. Nichols, what's your position with regard to him looking for work and getting a job?
I'm in favor of that, Judge, but I agree with the court. I think the monitoring needs to stay in.
For now, at least,
Monitor moving from house arrest?
Mm-hmm.
Okay.
Yeah. wear long pants and cover it up, I mean, whatever you need to do. But at this point, I'm not willing to do that based on obviously the nature of the offense. And so if you do this, Mr. Galmore, if you'll just send maybe a memo over and copy Mr. Nichols on it so that I have a paper trail to say that you asked me and that I granted that part of it, and I'll just sign off on a memo. Doesn't need to be a motion.
We'll do
But
that.
that'll just remind me to get it in the file so that it's clear. Also, we can send that to whoever has his GPS monitoring device so they know it's just for work-related purposes. You can go find a job, go to work, things like that, but it's not just a full-on go do whatever you want kind of
Well, Judge,
release.
actually, that's currently the status. He is allowed to leave only for work purposes currently. But because his wife is unable to work, her medical conditions made it much more difficult for them. So if the court would still consider just removing him from house arrest and keep the GPS, that would probably help a lot with the other life's necessities.
Okay. I know you've asked for him to drive her to this, there's been
Yeah, he was
doctors.
over to the airport the other day. But I mean, obviously in life, a lot of things like that pop up regularly, and if he's gonna wear a GPS device, the court will always know where he's at if it's important. But removing him from house arrest would be probably a big help.
Mr. Nichols?
Hard for me to really argue with that reasoning, Your Honor.
Okay, so I am going to require for you to remain in Jefferson County without permission. So if something happens, like the other day with the trip to airport or whatever, get with Mr. Galmore, he'll send me something, I'll approve or not approve. In Jefferson County, do what you need to live your life. I don't want, that doesn't include going to bars or going out at night
Maybe
or.
curfew is appropriate, Your Honor, unless,
Yeah, that would be,
if he ends up with a night job, obviously, that's different, but.
so let's do this for now. Let's make I'll release the house arrest, remain in Jefferson County with the curfew 8 p.m. to 6 a.m. If you get a job that interferes with, just get with Mr. Galmore and get those hours, whatever the job is, and we'll work around that. But primarily, I want you doing necessities away from your home, and that's it at this point, okay? All right,
Judge.
thank you.
Thank you, Your Honor.